Hello and welcome to the Disability Law Q&A. My name is Martin Willemse. I'm the Western Canada practice leader and managing partner at firm of Vancouver, South Route American. We welcome all questions via social media platforms regarding anything related to disability insurance, as well as critical illness and life insurance claims. We have offices in BC, Alberta, and Ontario, and we represent clients throughout Canada other than in Quebec and the territories. So, first question, and this is something that comes up fairly regularly. There's some confusion I've noticed that people, when they get a denial letter from an insurance company, there are various timelines referenced. One of them may be that the insurance company may offer to you an appeal process, and they may say you have to submit your appeal within 30 days, 60 days, 90 days, whatever the period may be. And further down in the letter, there may be another period mentioned. And that usually is referred to as the limitation period. And they may also mention the Insurance Act of your province. Those two are two different things. The appeal period is usually an internal timeline that the insurance company is providing to you to submit an appeal. All these disability claims are resultant from and stem from disability policies, which are contracts. Some of them, not many, very few, may provide a specific timeline within which you must submit an appeal. So that would be a contractual timeline. Others, where the insurance company may say to you, well, we're offering you the opportunity to appeal, you've got 30 days or 60 days. If it's not detailed in the policy itself, it's just an internal timeline that the insurance company came up with. And my position would be that policies are contracts, and if it's not detailed in the contract, they cannot rely on that timeline. That would be my position. But more importantly, you have to understand what the difference is between an appeal timeline and a limitation period. A limitation period is the timeline set out in the Insurance Act in your province within which you can take legal action. If you submitted an appeal to the insurance company, that does not interrupt the time from running within which you can file a legal claim. For most provinces, it is 2 years from the date that you knew or ought to have known that you had a claim. In other words, in BC, for example, if you had a claim that was denied, and that claim was denied without them ever having paid to you any benefits, the timeline should begin to run on the date of the denial, and it's 2 years from that date. It's generally the same in other provinces as well. The 2-year timeline is very important. Because if you submit an appeal and you continue to be engaged in the appeal process, and let's say it did take more than 2 years, and the final appeal was denied, then if you extended it beyond 2 years, you will not have a claim to pursue because you missed the limitation period. So if a claim is denied, I highly recommend that you contact an insurance lawyer, contact our firm, and have a discussion with one of our lawyers to understand what the difference is between the appeal process and the limitation period within which you can file a legal claim. And these consultations that we offer are free. So you can get a free consultation with a lawyer who will discuss with you the reasons for the denial as we understand it to be written in the denial letter. We can discuss your circumstances as well as your options and advise you of when the limitation period started to run, because it can be tricky. If a claim had been paid, the limitation period may only begin to run on the date of the last payment or the date that the last payment would have been made. So there are moving timelines, and you need to understand what the triggering date is and how long you have to pursue a legal claim. An appeal process is a process where you are submitting further evidence in support of your claim to the exact same entity that already denied your claim. If you were to think about a legal claim in the context of filing a legal claim, and you had a judge make a decision, and then you appealed that decision would go to a different court, different judges, completely different. With the insurance company, it is the same entity that initially denied your claim that is now reviewing your appeal. I will not say that all appeals are successful, but I will say, remember that the insurance company who denied your claim is now reviewing your appeal. If your claim is denied, you do want to have an understanding as to what your options are, what an appeal may look like, and what a legal claim may look like. We represent clients with legal claims. The benefit of that is when your claim is denied, if you have been never paid, or if you have been paid for a period of time and you had been dealing with the insurance company for, let's say, a year, 2 years, whatever the timeline may be, many people do not want to engage in that process anymore. So when a claim is denied, you want to understand what your options are through the context of a legal claim. All communications go through the lawyer. In other words, all communications come from, or that the insurance company may want to direct to you, will have to go through your lawyer. They cannot directly contact you. So when we represent our clients through the context of a legal claim, it allows our clients to focus on their treatment, to see their doctors regularly, without having the intrusion and the stress of having to deal with an insurance company. Again, if you've got any questions, you're welcome to contact us. As you soon see on the screen, you can also go to disabilityrights.ca for more information. Another question that has come up, and this is a general question in the context of a type of illness or injury or condition that a person may have. If you have a broken bone, one can see that on an X-ray or MRI or a CT scan. It's understandable why, where the disability stems from, and what the restrictions and limitations may be. There are other conditions where the person has symptoms. There is a diagnosis, but the diagnosis may have been based on exclusions of other conditions, or it may simply be that the person is having symptoms that are consistent with the condition, but we cannot see that condition or that illness on an X-ray or an MRI or a CT scan, or even through blood tests, for example, where you would have cancer. These conditions are generally referred to as invisible conditions or subjective conditions. Invisible is quite an insulting term, meaning that it's invisible. And I know somebody actually made a joke once with me on the other side of a claim that it's invisible because it doesn't exist, which is obviously not true. There are lots of conditions where you cannot see it on an MRI or a CT scan, yet they exist. Chronic pain may be one of them. The person may have had an injury many years ago, and there may be injury in the tissue, the soft tissue. There may be injuries in the joints. There may be other forms of reasons why a person has chronic pain. It may stem from another condition. It may stem from an autoimmune disorder. It may stem from chronic fatigue syndrome or fibromyalgia, which again, you cannot see on an MRI or a CT scan. Yet these conditions are very real and they can be profoundly disabling. Lots of these cases do get denied because the insurance company may take the position that there is no objective evidence or there is insufficient medical evidence to support the claim. The question is, what do you do when you have such a condition? You find that because of the restrictions and limitations or the symptoms, you are unable to perform the duties of your occupation. In that context, when that happens, you may find that you have to submit evidence more so than just an X-ray or a CT scan. So when your doctor completes the attending physician statement, which has to be submitted, have your doctor detail all the results of objective examinations, all X-rays and CT scans that you may have gone through, or MRIs or other tests that you may have had, whether you've been referred to a specialist, for example, a rheumatologist or a doctor of internal medicine, what other treatments you are engaging in, what your symptoms are, where they may stem from, what your doctor's opinion is on the diagnosis, and why it is that you would be unable to perform the duties of your occupation. Remember, a diagnosis is important, but the most important thing is functional impairment, to explain why you are unable to perform the duties of your occupation. If your claim is denied in that context, please give us a call and we can guide you through your options. Okay, there's a bunch of questions that have come in. The first one is a question from Leah, and this comes through Restream. I've been offered a part-time remote job while on LTD. I'm worried that if I take it, my insurer will say I'm no longer disabled. Is there any way I can protect myself? Every time that a question comes in as to what do you think your options are or what your rights may be, You want to consider what the language of the policy is. Some policies may provide that if you work for any profit or remuneration while you are receiving LTD benefits other than in a rehabilitation plan, your claim will terminate immediately. So you have to be very careful as to how you proceed with this. Some policies may provide, or many actually, it is the goal of the insurance company to get you back to work. So if there is a part-time job that is available to you, it depends on what that is. Is it with the same employer? What is the capacity that you are expected to exert in this job? How much are you going to be earning? How many hours will you be working? Part-time may mean that you are working yourself out of a claim. So it really depends on so many factors. It is worthwhile having a discussion with your doctor as to what your capacity would be, what the doctor supports you to do. I would not advise that you simply go and do this and not advise the insurance company, because then there would be issues with credibility, and there very likely may be that provision that I referenced earlier, that if you work for profit or remuneration outside of a rehab program, your claim will terminate. Now, sometimes insurance companies will say, or get doctors' input, may have a rehab consultant involved in your claim, and there may be somebody where they sent you, let's say it's a mental health case, and they sent you for counseling, which they paid for, which is return to work focused. And by the end of the 10 sessions that they may have funded, they may say, okay, well, we think you're in a position to engage in a graduate return to work program. That would be a time when, if you were to engage in that, the expectation is that gradual will become full time. So that would be deemed a part time return, I suppose. We're gradually increasing your hours. During that time frame, the insurance company will continue to pay your benefits if they are funding the rehab program. But if it is simply, I'm going to work on a part-time basis somewhere else, they may be scrutinizing that claim much more carefully to see whether that capacity can translate into a basis where they can deny the claim. I think it's worthwhile for you to contact us and have a discussion as to what exactly it is that you are planning to do and how this may impact your claim. So contact us on the screen, as you can see. Go to disabilityrights.ca for more information. Another question, this one from Reddit, and this is from Rena. I just got a letter saying my LTD benefits are being terminated because there's insufficient medical evidence, even though my specialist submitted a report. What should I do next? This is similar to what I had discussed earlier about invisible conditions. The insufficient medical evidence defense or denial is something I see very regularly. If they are terminating your LTD benefit, it means that they actually accepted it. So what changed? Why are they saying now that there is no insufficient evidence when they initially accepted it? What should you do? Contact us and we can discuss with you what your options are and have a review as to what did your specialist say? What did the insurance company request from your specialist? What other information do they have available to them to conclude that there is insufficient medical evidence? Sometimes they may say, well, we've received their letters from your specialist, or we've reviewed their clinical records from your specialist, and we do not see ongoing reports of your restrictions and limitations. Somebody may say they've got cognitive impairment and they have a mental health illness. Their anxiety may be stable, or their depression may be stable, because doctors often use that word stable. Stable just means it's not getting worse. Doesn't necessarily mean that the restrictions and limitations are not present. But the person may complain of cognitive impairment. They cannot focus, they cannot concentrate, they've got poor memory. But if that's not referenced in the clinical records, the insurer may say, well, you're reporting these things, but we do not see it in the medical evidence. Therefore, the evidence that's submitted is insufficient. So whenever you see your doctor, make sure that you report to your doctor on an ongoing basis, on a regular basis, what your symptoms are, what your restrictions and limitations are. How is your disability, your injury, your illness or condition impacting your ability to perform duties of everyday living? In other words, your activities of daily living. How are you managing in terms of medications? Are they impacting you? Remember, a disability claim is on the person who is submitting the claim. You have to prove that you remain disabled. So that evidence, unlike with an employment claim, it's not enough for the doctor to say, my patient is unable to work due to medical reasons. Your claim will be denied. You have to make clear when you see the doctors, and make sure that they document what you are reporting to them. If you report that you are having a better day or that things are getting better, what does that mean? Put it in context. Better in the context that the past few days my back was so sore that I couldn't move. Today I was actually able to get out of bed, make myself breakfast, do a few things around the house, and then I had to take a break. What does better mean? Because the moment the insurance company sees my condition is improving, they may look at that you're moving yourself out of the disability context and may deny your claim. To all these questions, I'm trying to provide some general information, but in a situation like you, Rena, why did they deny your claim? Why was there insufficient medical evidence? You really need to have somebody review this with you so that you can understand how to proceed. They may offer to you an appeal process, or it may be that you want to pursue a legal claim. When you have a discussion, a consultation with one of our lawyers, they will explain to you in great detail what your options are and how to, and you can decide how to proceed. In other words, make an informed decision. Okay, now I think this is a question from through YouTube at bro-d2m. It's been several weeks since I submitted my claim and the insurer hasn't responded. What should I do next? How long should I expect to wait? This is, again, a thing that comes up regularly. Insurance companies may say, well, if you submitted your claim, we're going to take 30 days or 60 days. Excuse me. However, not much more than that. At least they would say to you, the timeline would be as to how long they're going to take to respond to you to make a decision on your claim. But that sometimes does not happen, especially in the context of an appeal. When somebody has submitted an appeal, they wait and they wait and they wait, and then they contact us. The policy itself doesn't necessarily provide a timeline within which the insurance company has to respond to you. But these are policies, contracts that are peace of mind contracts. In the legal context, they are described as peace of mind contracts or peace of mind policies, meaning that you should have the peace of mind that when you have a disability and you submit the claim, that the insurance company is going to abide by their obligations to provide you benefits. By taking a much longer time to adjudicate the claim, that can be seen as them not doing what they're supposed to be doing under the policy. So in your situation, if you've submitted the claim and it's been a few weeks and you haven't heard anything, I would say be the squeaky wheel. Contact them, find out who is your case manager, get in touch with the case manager. If you cannot speak to the case manager, or if the case manager has been telling you it's going to come soon but then nothing happens, contact their supervisor, contact the helpline, find out who's dealing with this, be the squeaky wheel, make sure that you put things in writing as well, and advise them the consequence of the denial on your mental health and obviously on your finances as well. So that if there were to be a legal claim down the line, you can document the lapse and the lack of time or the time wasted in terms of the adjudication process. Okay, question I think also from YouTube at Reggie MacArthur. I just started a return to work, but just found out I'm going to take time off for serious surgery and recovery. It's a different condition though. Do I start a new claim? That is a very good question. And again, it's going to come down to the wording of your policy. Did you go back to work full time? Usually these policies will also have something called a recurrence provision. That's the LTD claim. Shorter may also have that, but much shorter. In terms of an LTD claim, it may be that if you go back to work and you work full time for doing your full duties, and you go off work again within the first 6 months of your return due to the same condition, then it is deemed to be a recurrence of the old claim. So no new claim will be filed. There will be no waiting period. They will continue where they left off. But if it is due to an entirely new condition and you have gone back to work, then I would think it is a new claim that should be submitted. Have a discussion with your human resources as well, but on the limited information that I have, it sounds like a new claim. If you've got questions on that and you want to give us further information, you're welcome to contact us. Okay, let's see. Question on Reddit from Kevin. My short-term disability was approved, but LTD got denied. Doesn't that contradict each other? Should I appeal or start over? Yes, it does. I often take that position as well. How does somebody's short-term disability claim get approved on, let's say, the end pay day is October 28th and October 29 LTD starts? Your condition hasn't changed. Everything remains the same, but LTD is denied. Yes, the definitions may differ slightly, but it is generally a different entity. Well, for you, you may know it may be an entirely different entity that adjudicated the long term. I've seen, oh, and it may also be a different team, likely is. If it is with one insurance company who adjudicates short term, or if it is the employer who uses short term and they self adjudicate, and then it gets to an LTD insurer, in other words, entirely different insurance company or an entirely different team of adjusters, that may explain why they deny the claim. Not that that's a sufficient reason, because it means that some other entity did approve it. If it is the same entity, in other words, you have submitted to insurance company A, short term, they approve it for the maximum period, and then the same entity, insurance company A, denies it, it is a contradiction. With the proviso that nothing has changed, that there isn't improvement to take you out of your disability. If that happens, please contact us, because we can provide you with information as to how to navigate that. Go to disabilityrights.ca, as you can see on the screen. Okay, another question from, I think through YouTube. This is from Juanita Breaklight. I've been off since late 2023 after a serious brain injury. My insurer is now asking me to go for assessment. I'm worried. Why are they asking this? Often with brain injuries, you may find that you've got post-concussion syndrome. That is often seen also as a subjective condition, because there's an expectation at insurance companies' end that there's a specific recovery period that they expect would happen in your case and in everybody else's case, within which they think the person should recover. If your disability stretches beyond that specific recovery period, which they based on medical association tables, they may look at this more closely to see, you say that you're not getting better, you say that you remain disabled, so they may have you assessed. With brain injuries, they may want you to go for a neuropsych assessment, in other words, a neuropsychological assessment, which is usually performed by a neuropsychologist, where they will do a battery of tests to see whether what you're reporting in terms of cognitive impairment is borne out by the results from those tests. Policies do allow insurance companies to have insureds assessed or examined. If that happens, you may want to have a discussion with your doctor as well. Report to your doctor your ongoing restrictions and limitations. It depends, I think, from the insurance company's perspective, what the outcome is going to be of that assessment. If the assessor finds that you do not have cognitive impairment, if that were to be the issue, or that you may have minimal cognitive impairment, or that your results are within the norm, they may terminate your claim. If that happens, again, do contact us. But the reason for your question, why are they asking this? Because I suspect that you have gone further down the line than what they would have expected the recovery period to be, and now they're going to assess whether there's other evidence to support that you are disabled. Juanita says, my doctor has said it will likely be several years before I can return to my normal life, if at all. Okay, so very crucial, Juanita. See your doctor regularly. As I said earlier in the segment, you need to report your ongoing restrictions and limitations. If you are not improving, your doctor probably should be referring you to other specialists as well. Have you been seen by a neurologist? If there are cognitive impairment issues, or if there's anxiety and depression, have your doctor also refer you to the psychiatrist if things are not improving. Because you want to show at your end that you are doing everything that is required from you under the terms of the policy. And that means seeing the doctor regularly, being under the appropriate treatment of specialists, and receiving appropriate treatment for your condition if it is not improving. If they deny your claim, please contact us. Jason J. 8246 through YouTube is asking or saying, I have agoraphobia with a panic disorder and am on LTD, I suppose. I'm doing walks with a peer support worker every week. Will this eventually lead to my benefits being terminated? The fact that you're walking with a peer support worker, I cannot see how that would be a reason to terminate your claim. Yes, the insurance company might look at that as a contradiction, but obviously the peer support worker is part of your treatment. If you have agoraphobia, I'm sure they're doing exposure therapy for you, where it is recommended that you have to do these things as part of your treatment to get better. So, as long as this is documented by your doctors, I'm sure this was recommended by one of your doctors. If not, discuss it with your doctor to make sure that the doctor is aware of it as well. I'm sure your doctor will be supportive of it, but continue to report to your doctor your ongoing struggles. I have seen cases where there have been incidents of, for example, the person cannot work because of agoraphobia. Then the insurance company may turn around and say, okay, well, we're going to be looking at this in terms of if you cannot leave the house, maybe you can work from home. So you have to be clear with your doctor what your restrictions and limitations are. If it is a panic disorder as well, maybe that would mean you're taking medications. The medications may impact your cognitive functioning. It may lead to brain fog. You may oversleep or undersleep. If you're having panic attacks and there are physical manifestations of those, report that to the doctor so the doctor understands why it is that you cannot work, and the doctor can support you in that claim. If there were to be a question from the insurance company for your doctor to complete a form, that your doctor can do that also from the perspective of having an informed clinical entry and chart entry to look at when they complete those forms. Sounds like I'm going to be beating a broken horse, but if they deny your claim, please contact us. I know that it can be, for many people, scary to contact a lawyer or to speak to a lawyer, but when they do, especially in this context, these consultations are offered on a free basis. There's no pressure. It's your decision as how you want to proceed once you have the information. But do yourself a favor. When you speak to us, we're going to explain to you what your options are. We're going to discuss with you the denial. We're going to discuss with you why the insurance company denied your claim, what may be necessary in order to get that claim approved, and then you can make an informed decision as to how to proceed. With all of that being said, thank you everyone for tuning in. Okay, there's one more. Okay, I'll go through this quickly. Teresa Vandenberg, is there a good way to prepare for functional assessment? I just had this dropped on me by my insurer. I'm so anxious about what it could mean. There's a lot to be said about this. Functional capacity evaluations, they're going to be testing a few things, not just your function. They're also going to be testing your effort. If you do not provide sufficient effort, then they may say, well, you did not exert sufficient effort, therefore the results may not be reliable. Functional capacity evaluations are there to test what your function is, your residual capacity. So they will understand what your limitations and restrictions are, but they will put you through a battery of tests. And some of those may be done to test malaria as well. So when you go, firstly, have your doctor support to make sure that this is something that you can engage in. And then go, try to do your best, but not to the point that you can injure yourself. I often say with these functional capacity evaluations, I don't believe that they can test pain to that extent. They can observe pain mannerisms and pain behavior. Can they measure fatigue? Well, I don't believe so. If pain and fatigue are the limiting factors in your condition, that may be difficult to measure. Having said that, they sometimes do test your blood pressure to see if it increases, and they look again at visible signs of pain, maybe fatigue as well. But all these things are measured, but often they don't follow up. So a person may push through on the first day of the testing and do whatever they can do to show that they are exerting effort. But there's no follow-up in the week that follows, where the person may now have re-aggravated a condition, may have a worsening or a relapse, where they don't get out of bed, or it may take a much longer period for them to recover. If there's no follow-up, then I would say that there is a lapse in having done a proper job. So speak to your doctor. I understand that it may be anxiety-inducing to go for this assessment. You're very likely required to do that through the process of, or through the provisions of the policy. If you want to discuss this further, you're very welcome to reach out to us as well. I wish you all the best, Teresa. Okay, go to disabilityrights.ca if you need more information. And with that, it brings us to the end of the session. Thank you, everybody, for tuning in and for all the questions. I hope that this was helpful. Our next disability law Q&A will be on Tuesday, November the 11th. And our next employment law Q&A will be on Thursday, October the 30th, which is in 2 days from now, with Angus Wilson. Thank you, and I wish everybody a great day.